technically, there seems to be two judgments. I think they've done a separate judgment dealing with slightly different issues in respect of the Scottish case. I've only read the English law judgment. But, my gosh, it is a wonderful piece of legal work. And all the more so that it's unanimous. And of all the remarkable things about this judgment, the fact it is unanimous is the one which stands out most starkly.
Tell me why that's so significant.
Well, nobody was expecting a unanimous judgment. On Miller 1, if you recall, the judges did split. And if you'd asked me or you'd asked anybody else with any interest in constitutional law, even a month or so ago, how the judges would jump on this, we would have said, well, prorogation is just one of those non-justiciable things. It's just an entirely political decision for the Prime Minister. But somehow, with the genius of Dominic Cummings and Nicky DaCosta and the Number 10 operation, they have converted something which was inherently non-justiciable to an 11-0 victory at the Supreme Court, just by their own tomfoolery.
So if they had suspended Parliament, or actually, no, prorogued it, but for a period of time that was traditional, none of this would have happened? Well,
we've just got to take a step back to see how the court has approached this.
Please. What
the court had to do, first and foremost, was work out whether this was justiciable. That doesn't mean, is it political, is it legal? It is actually, is it a question which is capable of a legal answer? Just like a puzzle might have a mathematical solution.
Right, yes.
Can they convert it into a legal issue? And that was the real difficulty, because it's literally unprecedented. There's never been a case on this point before. They've worked out that there is a rule they can adopt, and that is essentially the government cannot ask for a prorogation unless it has a good reason. And that is more or less what the Supreme Court has decided. Now, once they identified that legal rule to apply, then they were able to look at the evidence and say, well, there's no good reason. And they didn't even have to go into the murky depths of trying to work out bad faith or undue motive. They were just saying, well, these are the effects. Bills are falling. The executive cannot be scrutinised. MPs can't ask questions. What is the reasoning for this? And they couldn't find any reasoning. And in the absence of any reason for it, they had to find it was unlawful.
I suspect you had your nose in the files and you didn't hear Lord Falconer on the programme a few minutes ago, who said something remarkably honest, I felt, which was that nobody knew for sure which way it was going to go. There are plenty of eminent people thought it might go the other way. But once the judgment was explained and the unanimity, as you also stress, was established, it was impossible to see how it could have gone any other way. He said sort of by tea time, this will be an absolute no-brainer. It wasn't a phrase he used, but that, I thought that was fascinating. Do you agree with that?
Yeah, I think if the Supreme Court was to go against the government on something this fundamental, it is better if it's unanimous. And it may well be that one or two of the more hesitant judges thought, well, we're in for the pound now. We're going to go and do this. We're going to do it all together. A bit like that bit in Doctor Who when all the doctors come back to help the War Doctor.
It's exactly like that.
And the unanimity also means that it's so much more hard for people, pundits and politicians, to attack this as a politicised decision. And the final thing about the judgment...
Yes. Well, they were even casting aspersions upon the Scottishness of the last court, weren't they? Whereas that ludicrous criticism gets blown completely out of the water by the judgment and more so by the unanimity.
And the court has been very careful, and this is the last point, on the remedy. They've not made any injunction, they've not made any order, they've just made what's called a declaration saying what's lawful, what's not lawful. And they've just said, well, it's entirely null and void. It is as if the Privy Councillors walked into the Queen's chamber with a blank piece of paper. What they asked the Queen to do had no legal effect, and so what the Queen then ordered had no legal effect. So what this basically means is that people could just turn up to Parliament, and it's never been prorogued. The prorogation never happened.
And I'm hearing from MPs, and in fact we just spoke to one, who are gathering in Westminster with the full intention of going back to work. Can I ask you a slightly cheeky question, David Allen Green, which is...
Go on.
Go on, he says. I mean, I've almost fallen into Charlie Falconer's trap already here, or into what he described, because I want to ask you, how on earth could they have thought that they'd get away with this?
The difficulty was identifying a legal rule for the court to apply. Once that was unlocked, and you will see in the judgment, it follows very carefully David Panik's submissions. He was saying, there is a problem here. How do we solve it? And the difficulty in this case from a lawyer's point of view was the lack of precedent. So what Panik had to do was look at all the other cases on constitutional issues and try and glean from them a general principle which would apply to this case. And masterful advocacy was he was able to do that. And once the government had no answer to that, then it was more straightforward. But I was still expecting at least 3 or 4 of the judges to say, no, this is not something we should be getting involved with. But no, the government's case was demolished. And if this was a normal public law case,
yes,
with any other public law decision maker criticised in this way, you would expect that public law decision maker to now resign.
Well, I mean, we keep using words like normal and ordinary, and I completely understand why, but these events, as you describe, are anything but. The final question, because I have Anna Soubry waiting for me, is one of your most winning observations in recent weeks, David, is that constitutional law is not supposed to be exciting. When you mention... What?
It is really a bad sign that you're having brummy commentators explaining constitutional issues. There's something really wrong with our political system if that's happening.
Well, and it's a winning and an amusing observation, but you're getting 8,000 likes when you announce on Twitter that you're coming on this programme. So the enthusiasm for hearing your explanations is immense. It even reached royalty in the guise of Nigella Lawson herself giving you the endorsement and the encouragement to come on.
We need more Nigella and less Nigel in Brexit. We really do.
I'm not going to argue with that. Hang on. This isn't over, is it? I mean, the judgment's incredible, but have we reached the top of the mountain and now we climb down, or is there more madness on the horizon?
You would hope there's no more madness on the horizon. This is a comprehensive resetting of the relationship between executive, judiciary and legislature. This is the last word on the balance of powers. And so you would hope there'd be no more constitutional cases. But if the government is mad enough to try somehow to legally evade the effects of the Benn Act on forcing a request for an extension on Article 50, then yes, we could probably see some more constitutional-like litigation. And I do not think the courts are in the mood for nodding along in an indulgent way with silly threats from the government that we're not going to comply with the law.